You can have a seat, so. Generally, you said you had an issue we need to take up before we bring the jury back.
State calls Terry Pate.
Come around. Is that the phone up here? In that?
Yes.
Raise your right hand. You solemnly swear or affirm the testimony about to give to be the truth, the whole truth, and nothing but the truth, so help you God. I do. Have a seat.
Can you state your name and spell your name for the record, please?
Terry, Terry, Pate, Pate.
And where are you currently employed?
The Knoxville Police Department.
What's your current assignment?
In the Organized Crime Unit.
And how long have you been with the Organized Crime Unit?
Since 2016.
And what does the Organized Crime Unit do?
We investigate narcotic offenses, weapon offenses, vice crimes, things of that nature.
And is that what your employment was on September the 14th of 2019?
I was actually assigned to the Appalachian Haida Overdose Task Force,
Okay.
which is a task force inside of the Organized Crime Unit.
Okay, so it's a specific task.
Applied in 2019?
Yes.
Okay.
And how long had you been with HIDA at that point?
We transitioned over from CERT in 2016. I was placed on a gang task force within Organized Crime Unit at that time, and then shortly thereafter moved to the Haida Overdose Drug Task Force.
Okay, Investigator Pate, have you been involved throughout your career with investigations involving narcotics?
I have.
And when did you start with the Knoxville Police Department?
I started with the Knoxville Police Department in 1999.
And how long have you been on specialized task forces dealing with narcotics investigations?
Out of all of those years, I spent about 3.5 years on patrol. The other were for drug-related offenses.
Okay. I am going to hand you a number of documents and ask if you recognize them. Well, first, let me ask you this. This item right here in front of you that is listed as Exhibit 48, do you recognize that? You can open it and look at it if you want to.
Yes.
What is that?
It is a iPhone 6 that I had to rebuild.
Okay. And so the iPhone 6, that's Exhibit 48, is that the iPhone 6 that has to do with the Robert Howington case?
It is.
And who asked you to rebuild this phone?
I was given that phone by Investigator Wardlaw.
What all did you have to do to rebuild the phone? Explain that to the court, please.
I had to essentially finish taking it apart. When I did that, I noticed there was damage to the casing or the frame of the phone. Also, there was standing water on the phone and inside of the components of the phone. I had to replace the front assembly and digitizer for the cell phone as well as the battery for it.
Why don't we get to the part that may be objectionable? I mean, none of this is, he's going to be allowed to testify on this. What is it that you're asking the court to rule upon before we...
So as part, did you do an extraction on this phone?
I did.
And as part of the extraction that you did on the phone, did you find items that were of interest?
Yes.
Let me hand you these 6 documents and ask you, do you recognize those 6 documents?
I do.
And what are those 6 documents?
It is a list of the search history.
Is it the entire search history of the defendant's phone?
I don't believe it's the entire search history.
But it's portions that that were relevant to this case. Is that correct?
Yes.
I wonder if we could make this exhibit, I think we're at 49.
ID only 49.
Exhibit 49, and can you explain to the jury what a search history is? Or excuse me, explain to the judge what a search history is.
I know what search history is.
Okay. Can you tell the judge the items of interest in this particular search history that are printed there in front of you in that exhibit?
Yes, there's several searches. One of which was just RP15.
Does that mean anything to you?
Yes, it is
the. What that means.
It's the markings on a oxycodone pill. It's an oval white pill, and of course, the oxycodone is used to treat chronic pain.
What's the date of that search?
June 27th, 2019.
What about the one on the first page? What does that say?
Both Buzz Perone, 7.5 pictures.
Okay. And is that also a drug?
Yes.
Can you go to the third page? Oh, what's the date on the first one?
It is June the 12th of 2019.
If you go to
12 of 19. Is this an actual photograph or just a search?
It's just a list of the searches that were conducted on the device.
So the actual search is Buzz Perone 7.5 pictures? Is that what it
Yes.
says? Okay.
go to the third page. What is the highlighted search on the third page?
How much do the orange Opanas cost?
And what's the date on how much did the orange Opanas cost?
8/3 of 19.
Okay, does that orange Opanas, does that mean anything to you as a drug investigator?
Yes, it's a medication used, a controlled substance used to treat chronic pain. It's oxymorphone. Again, it's a controlled
What's the
substance.
date on that?
8/3 of 19.
If you could go to the next page. What's the search on that page?
Is Buzzbar a benzo? And that's the brand name of the first Buzz Perone, Brony 7.5 pictures. It's the brand name of that.
Okay. And the search was, is that a benzo? Do you know what benzo means?
I do, and it is not a benzo.
What is a benzo? What is that short for?
It's a benzodiazepine.
What is that?
It's it would treat anxiety, and it is controlled.
Low level. It's Xanax, Valium, something like that.
Yes.
Okay.
Okay.
What's the
You go-
date on that?
8/4 of 19.
You go to the next page. What's the search?
Does Buzzbar show up on drug test?
What's the date of that?
8/26 of 2019.
Is there any other searches in that package? Last page.
How long does alprazolam show up in hair follicle drug test?
What's the date on that?
8/27 of 2019.
And the specific drug referenced in that you said was alprazolam?
Yes.
Is that a controlled substance?
It is.
In the course of looking through Ms. Adams' phone, did you also find pictures that were unknown?
Yes.
What was the date of that last search? The one about alprazolam?
8/27/19.
Okay. All right, go ahead. General McDermott asked you about photographs.
Yes, there were a couple of photographs.
Okay, let me hand you this packet of information and ask, does that look familiar?
Yes.
What is that?
It is a photograph. It appears to be like a coffee table or some sort of table. And on that appears to be multiple plastic baggies, some of which contain a green leafy substance, which to me looks like marijuana.
Okay, and that particular photo, is that a photo that you have a date for?
Yes, 5/22 of 2019.
Okay, if you could go to the next photo. Or wait, this goes with those. This
okay.
one.
That was-
This one.
yeah. It's essentially, it's more of a close-up of the first photo, but 5/22 of 2019 is the date on that as well.
And what's in the second set of photo? Second photo. This one.
It appears to be the plastic bags and a plastic bag containing a green leafy substance. And in the first photo, there appears to be a digital scale
And why would a
setting-
digital scale be significant to you?
weighing out narcotics, especially if it's laying next to narcotics.
And if you could hand me the next set of pictures and tell the court what that is.
Appears to be a screen capture of marijuana.
And what's the date on that?
5/21 of 2019.
And if we could make these collectively the next exhibit.
50 for ID only. That's the photos. Yes.
In the course of your investigation, did you also look at some text messages in the phone that were from the owner of that phone to someone named Antoine BD?
Yes.
Into this document and ask, is that some of the phone conversations? Or the
Yes.
text message conversations?
Yes, the text communication.
Now, if we could make this the next exhibit.
That'll be marked and filed as 51 for ID only.
If you can start, do you start at the end? Is that how it works?
Well, we can look and see which way it's going. If it's ascending or descending. It looks like it's ascending.
Okay.
So,
And so you start at the very end of this document. Is that
Yes.
correct? All right. If you will tell the court who is sending that text message and then read what it says.
the first text message going up is sent from the device that I extracted this from.
Is that exhibit 48?
Yes.
Okay.
Says we both know I wasn't acting crazy. You the one who was loud AF and just thought I would let you fucking like I said you only a dad when it's convenient. I can never call you if we need you. So B, you spend more time with hoes than our precious daughter, but you're the one missing out, and you will regret it one day. Maybe not today, but you will. And this, you are disrespectful AF. Going to have a junkie hoe tell me y'all not worried about me. But when I have been worried about you, but you had the hoe around our baby, you got issues, and I will let them junkie hoes deal with you and your issues.
What is the date and time of that text message?
8/4/2019.
And that's from Miss Howington to Antoine D, correct?
BD, Antoine BD.
Could we read the last 4 words of that text?
The last 4 words?
So you said, I'll let the junkie hoes deal with you.
And your issues while I enjoy our daughter.
Okay, if you could read the next text message. Who is that from?
That is from Antoine BD, and it was on 8/4/2019. Like that, exclamation point, she's only 5 years old. Then you have a fucking gun. And then followed up right after that from Antoine BD, continuation, sitting on the nightstand where a child can reach it. WTF is wrong. Then continuation of that, same date. Then you yelling at her for going into your room like who really act.
Okay. What's the next text exchange?
Again from Antoine BD to the owner of the device. With you, exclamation, but all you got to say is some BS about a bitch. Then, follow up from Antoine BD to the owner of the device. You are an old crazy drunk. Think about others feelings, you damn nut, you. Then follow up, continued. Lost custody, WTF, you gonna let that happen next. Continued again from Antoine BD. Ain't gonna be satisfied until something worse happened. You already, and then it cuts off.
Is there a response after that?
Yes.
What does it say?
This is from the owner of the device to Antoine BD, 8/4/2019. IDK, what you're talking about, so go do what you do best and argue with the hoes you sponsor while I enjoy our daughter. Follow up from Antoine to the owner of the device, same date. You better get your shit together. And then it goes 1 and 2, but speak bad about somebody else. You need to look in the fucking mirror, letting fucking junkies babysit her while you're out half naked looking like a hoe, exclamation point. Got the nerve to be around Dez dressing like that, but got the nerve to.
Is there a response?
Yes. From owner of device to Antoine BD, same date. Trust me, I had my shit together till your ass came along and been a thorn in my side ever since you caused me to lose my son and is my ass for 2 years. So say whatever you want about me, but I bet I take better care of Dez than Stacy does, Trey's badass, and WO or without you or your family.
The end of that, the end of the relevant portion of that text exchange?
Yes.
Sure. I believe that in our earlier hearing, we've already discussed the text messages with Joe and with Callie, so I don't know that we need to necessarily go into that now.
I take it you object to this.
Yes, sir. I think it's.
Well, just wait a minute.
Well,
Just wait a minute.
could I talk to the witness?
You may be winning. Just wait a minute. Is Mr. Oliver going to testify?
At this point, Your Honor, this is the witness that we have that's going to testify.
How does what Mr. Oliver asserted in a text message, how is that not hearsay?
So, Your Honor, the reason that I think that this is relevant admissible evidence is twofold. First, the text exchange. Do you want me to talk about this first, or do you want me
Let's
to
talk
talk
about the text exchange.
Okay, so for the text exchange, we know in this case that the defendant tried to destroy her phone. So her motive for destroying the phone is certainly something that's absolutely relevant in this case. She told the detectives at one point it is because there's drug information in the phone or something of that nature, but I think it's also relevant that in this particular phone that she is trying to destroy, there is a conversation that she's having with Antoine where he's talking about how she's leaving the gun out in the room. And she knows that that text is in there, Your Honor. And so the fact that she wants to destroy this phone that has a text message in it where somebody has said to her, you leave guns out, and that's messed up, is something that goes to her state of mind, her consciousness of wrongdoing, and her motive for wanting to get rid of this phone. I think it's absolutely relevant in this case. She knows that that's in her phone, and that's something that she is trying to get rid of so that the police don't see that, Your Honor. We believe that it's relevant and admissible.
Why is Mr. Oliver?
Your Honor, we've not made a decision about whether he's going to testify or not. Really,
Do you understand he's making an assertion about
Sure.
this gun which she doesn't acknowledge? Let me finish.
sorry.
he's making an assertion about the gun, which is not subject to cross-examination.
She
And
said,
this isn't an admission that she's making, it's an assertion that he's making, I've observed this. If he had texted her and said, I witnessed you kill Destiny, would that be admissible?
if she then tried to destroy the phone that had the text message in it that said, I saw you kill Destiny, and she tried to get rid of that phone, absolutely it would, Your Honor. And not only that, she says back, trust me, I had my shit together till your ass came along. I think that that's a tacit admission in this case, that she's acknowledging some wrongdoing.
The only way this is going to come close to coming in is if you can convince me that there's a tacit admission here. I don't see how else I can admit this.
She says, trust me, I had my shit together till your ass came along. That's her words right there in the very last text message.
All right, on the text messages on, Mr. Whalen, what do you say?
Judge,
We're going to deal with each of these piecemeal. So
Right.
talk to me about the text message.
So in the text message, the chain in which he says something about the nightstand is 353. And then he says, is that the same day, I think? Same day at 3:56, 3 minutes later, the fourth one down on the front page. You better get your shit together. So in between that are 1, 2, 3, 4, 5 messages that say nothing about. There's no tacit admission from her, 6 messages between the nightstand text and the get your shit together text. So how, I don't know how the state's saying I had my shit together till you showed up, which is another 3 minutes later in response to a different text. So I'm saying there is no tacit admission, and this man's been sitting outside this courtroom for a week, and we're sitting here talking about whether or not Mr. Pate's going to get to say what Antoine Oliver says, who has been described, Mr. Riddle called him a nutcase in the interview, been described as a horrible domestic abuser, and we're going to let him sit out in the hallway and let Mr. Pate, I don't know, ventriloquize him into the courtroom, and it
Make
makes
legal arguments. I don't.
Judge, it is a legal argument. The man who made the statement is sitting out there upstairs by the coffee shop. Last I saw him 20 minutes ago. He's been here all week. Why are we asking to have another witness read his texts? If he wants to come in here and testify and subject himself to cross-examination, I say, come on. But this is not the witness. I can't cross-examine this witness about those texts.
Here's the problem, General. Given what the subject matter of this is, even if I give them a curative instruction, even if I buy your argument that this goes to her state of mind about just trying to destroy that phone, I have to instruct them that the only reason they can consider that is because of her state of mind, and this may have been the fact that this assertion, true or not, was made in the phone was why she was destroying it. I'm very concerned that under 403 that if I have to do the balancing test the law requires me to do, that we don't get there. Now, if you want to put Mr. Oliver on, then that's a different can of worms that we're dealing with. Then we're dealing with her conduct prior in time to the night of September the 14th, 2019, and this may be corroborative proof of his assertion that he saw a gun on her nightstand. But that's your call. But I'm not comfortable putting this in this fashion because this is central to the issue in this case, and it's a statement that he can't cross-examine. It's rank hearsay. And I don't see this. If I agree if she had made an immediate response back, but Mr. Whalen correctly points out there are multiple other things he says before her first response back. As I said yesterday, I think this record is clean at this point. I don't want to build error into it.
Will the court consider if the defendant takes a stand addressing this issue again?
That may be fair game if she takes the stand.
Thank you, Your Honor.
If she takes a stand, the hearsay would be admissible.
Mr. Whalen, we're not there yet.
Well-
I've ruled that for purposes of the state's case in chief, this is not coming in.
Thank you, Your Honor. Does the court want to hear the argument as to her searches?
All right, make your argument on that.
Your Honor, I think that the search history that we have here is significant and important. The reason being is because the defense has made quite a big deal in their cross-examination about her having all this medication, her having PTSD, and here we have the medication in some of these instances that she's specifically addressing when they're going through her medication in that interview room. She talks about buspirone, and here she's doing things that are indicative of selling that exact same medication. They've made a big deal about how she has PTSD, and I think the fact that she is selling the medication that she supposedly needs for PTSD is something that's relevant, and the defense has made relevant in this case.
Where do those searches tell me she's selling that medication?
Well, Your Honor, if she is looking up whether it will show in a drug screen. I think the reasonable thing for anybody to believe in that case, if she's asking if it's going to be in a drug screen, if she has a legal prescription for that particular narcotic, it's not going to be important or significant to her whether or not that shows up in a drug screen. The reason she's
Is
looking...
it not just as reasonable that she could be illicitly taking it and worried about it showing up in her drug
That
screen?
could be it too, Your Honor, but I think that it's also reasonable given the other testimony that we've heard in this case that she's selling these narcotics. And I think that's something that when the defense stands up and tries to paint this picture of this person that's on all these medications and has all these issues, that the state should be allowed to say, well, it appears that this person is also selling that medication as well. I think that that's fair.
Okay, we all want to be fair, but I have to follow the rules of evidence as promulgated by the...
I'm talking about the balancing test that the court has to do to determine if this outweighs, Your Honor, and that's why I'm saying I think it's fair game when the defense has made a big deal in this case about all the medication she's on to also point out that there are things in here that are indicative of her selling her medication.
I have allowed the state to introduce evidence around the time frame because I think it is highly probative and it gives context to what the conversation she was having with Mr. Key that night, that he was attempting and had in fact bought pills from her in the past. But these searches, to me, are just as easily explainable that she's trying to figure out what she can take and what she can get as they are that she's selling. I'm not reading the same thing into this that you are.
Okay.
You want to be heard on this?
Yes, sir. Just briefly. She is prescribed this drug. Sometimes she's asking about what the photo of the pill. If you found the pill and it's sitting loose, you might want to know what it is. I don't think there's anything in here that suggests sales in any way. And I don't.
Here's the
think
way I
so.
look at it, folks. If I'm wrong, I'm wrong. But this is just the way I look at it. If she were under indictment for aggravated child neglect and felony murder in the perpetration of aggravated child neglect, and her daughter had died from an overdose, and there was evidence of her illicit drug use before and during the period of time in question, I think it's highly probative. But that's not what she's indicted for, and that's not what the proof in this case is about. She is accused of engaging in aggravated child neglect, which resulted in her child's death because her child was shot and killed. I have allowed the state to put in evidence through Mr. Key that he was attempting to buy pills from her that night, that he had bought pills from her in the past. I'm going to permit Detective Pate, as a drug investigation expert, to opine about the length of time that a typical drug transaction takes place, because that's directly material, because we have an individual showing up who's there for 1 minute and who leaves the next, and I will allow him to opine that in drug transactions many times firearms are present. That's as far as we're going with that. I just don't see this as adding anything more to the equation. So I'm going, unless it's made material in some other way, at this juncture, I'm going to say we're not going to get into it.
Okay. And the same thing with the pictures of the drugs on the table that's in the house that we've been talking about this whole entire time.
Once again, we're talking about marijuana that was seen in the house, some 5 months before the homicide. Do you want to try this case twice?
Your Honor, I think the state's position is that this is relevant admissible evidence. I understand the court's ruling, but that's what I'm asking the court to allow us to do, and I understand the court's ruling.
If she, through cross-examination or testimony elicited in her case in chief, makes it relevant, we will reconsider the issue. At this juncture, I don't think we need to go there. I think you're building record error in where you don't have it.
Thank you.
Okay, everybody bring Jerry back.
Can I have like a minute and a half to stay on stuff straight?
Tell me who we got left. We've got Investigator Pate.
Yes, and then I have the medical examiner. You said that I may ask him about the length of drug transactions and also if firearms are frequently present.
Yes, based on his training experience, he's not going to opine on this particular case that this was a drug transaction, but I will allow him to testify that in his, based on his training experience, that drug transactions are typically this length. And he can talk about that and the fact that in his experience there have been firearms present oftentimes in drug transactions. There's no question this was a firearm here, but as far as how the firearm was utilized, we're not going there.
Judge, if you're not going to allow him to say that the 63-second visit at the house is a drug transaction, for him to testify that drug transactions happen in a shorter period of time, what else would a jury expect to be able to think about that?
Are you wanting me to have him say that?
No,
this is a
I
drug
don't,
transaction?
it's nonsense, and I think they say everything's admissible, but what they can say is someone goes in and they're in there for 63 seconds. Where is there any evidence that that was a drug transaction? And you're not going to let him say it, so why let him say, well, 63 seconds could be a drug transaction?
I'm going to allow it. You can argue that it wasn't. She can argue that it was. I think it's fair game, given the fact what she was trying to do earlier that evening with Mr. Key. All right, ready to bring jury in?
State's ready.
Line the jury up. Waive the call for the state.
Waive the call.
For the defense.
If you could introduce yourself to the jury, please.
I'm Investigator Terry Pate with the Knoxville Police Department.
For the record, you were sworn a few minutes ago. Is that correct? Investigator
Yes, sir.
Okay. And can you spell your first and last name for our court reporter, please?
Terry, Terry, Pate, P-A-T-E.
I heard you say you work for the Knoxville Police Department.
Yes.
How long have you been employed with the Knoxville Police Department?
Since 2019.
Since 2019?
Yes.
And what is your current assignment?
I'm sorry, 1999. Sorry.
I thought that was a little... Okay, since 1998, is that right?
Yes.
Okay. And what's your current assignment?
I'm assigned to the Organized Crime Unit.
And can you explain briefly to the jury what the Organized Crime Unit is?
We are charged with addressing narcotics investigations, vice crimes, and we assist other units within the police department.
Okay. And how long have you been with the Organized Crime Unit?
I've been there since 2016.
Prior to 2016, were you with the Repeat Offenders Investigative Unit?
Yes.
And when did that start?
2007.
Okay. And prior to that, where were you assigned?
In 2002 to 2003, I was assigned to a special investigative team that was on patrol, but in plain vehicles. In 2001 and 2002, I was assigned to the as a staff officer in the West District Captain's Office. And then 2003 to 2006, I was assigned to patrol.
Okay. So have you been mostly with units that have to deal with narcotics?
Yes,
Okay. So do you do undercover investigations dealing with narcotics for the most part?
I have. I'm involved in those.
Okay. And when you say involved, can you just briefly explain to the jury what you mean by a narcotics investigation?
So depending on the type of narcotics investigation we do, sometimes we utilize a confidential informant. That means that you're doing surveillance or handling the confidential informant, or in some cases I'll be used in an undercover capacity to purchase narcotics.
So when you say confidential informant or that you're being used in the undercover capacity, do you actually go and purchase narcotics from people or have
Yes.
someone else go do that on behalf of the police? Is that
Yes.
what you're talking about?
If we use a confidential informant, we use them and we do surveillance while we go or while they go and purchase the narcotics. If it's undercover capacity, then I would be the one that goes in and purchases the narcotics.
And so in the course of your employment with the Knoxville Police Department, how many narcotics transactions would you estimate that you have either observed or actively participated in?
I've actually participated in thousands of controlled buys.
And what about just observing?
It would be the same. Anytime our unit's not very large, so anytime someone's doing a buy or controlled buy, I would assist a lot of times in those.
When a drug transaction takes place, can you tell the jury if that's typically something that's a lengthy transaction or a short transaction?
The actual transaction portion of a controlled buy or narcotics purchase generally is very short. There are times to where it's a waiting game for you're calling a person and they tell you to wait, or you can't get a hold of them, and it takes time to do that. But the actual portion to where, like if I go in and buy narcotics, or if I meet someone to purchase narcotics, it's very quick. You don't want to linger around and get caught with the narcotics, all right? If I'm someone that is suffering from addiction, I want to get the narcotics and use them. I don't want to hang around and talk sports with someone. So it's generally, they're very quick.
In the course of a narcotics transaction, have you found that firearms are something that typically is associated with those transactions?
Yes, there's inherent danger when you're dealing in illegal substances. Getting robbed, protection, getting robbed of money, the narcotics, home invasions, and there are times where people, they may show their weapon, have it out, like just out in the open, just as kind of like a warning. You know, it won't be easy to come in and rob me. It wouldn't be worth it. Sometimes they hide them on their person and you don't see it, or they put it on their person so you can see it, so it's close to them. But very often there are transactions where the firearm is presented during those.
Stop for a second. That's good. Ladies and gentlemen, the same instruction I have given you previously. I want you to remember you'll be given further instruction on how to receive expert testimony in the court's written instructions. But the parties have previously agreed that Investigator Pate is an expert in the field of narcotics investigation, so that's why he's being allowed to offer the opinion testimony he's offering at this time. But once again, you'll receive further written instructions on how to receive expert testimony. Go ahead.
So, Investigator Pate, did you become involved in this particular case having to do with the death of Destiny Oliver?
I did.
And how did you become involved in this particular case?
I was contacted and made aware that an investigator with the police department had a cell phone.
And if you can just move a little bit closer to that mic. There you go.
I was made aware that there was a cell phone that was damaged and possibly had water damage, but also had structural damage, and they wanted to see if I could repair it. I wasn't hopeful for it, but I did get the phone and I was able to get it working.
you stop here for just a second? Will you put these on? I'm going to give you Exhibit 48 and ask you to recognize Exhibit 48.
So this is the cell phone that I did repair.
Okay, and so who did you receive that cell phone from?
Investigator Wardlaw.
Okay, and so when you received the cell phone from Investigator Wardlaw, can you explain to the jury what the condition it was? What condition was it in?
So when I got the phone, it was wet, and I straightened it. I'm not sure if you all have seen this yet, but it's still kind of bulged. But the structure or the frame of the phone was bent, and the screen that that contains the digitizer and the ribbon cables that connect it to the other part of the device was shattered. And then again, it was wet. I had to place tape over the screen because when removing that, I didn't want the shards of glass coming off, and it wouldn't. How we have to remove it completely or hold it up, we have to use like a suction cup at times. When I opened it up, there was again, I could see where the frame or the structure was damaged. It was bent, and there was standing water and liquid within side of the device as well.
Now, in the condition that you received that phone, would you have been able to go through the phone and look through the phone?
No.
Why is that?
It had no power, and when the screen is damaged that bad, a lot of times you can't manipulate the things you need to do on the phone to do an extraction or to search the cell phone.
Okay, let's say that you would have been able to turn on, if you were able to turn on the power, would you still have been able to look at the screen and determine what was on the phone and the condition that it was in?
I'm not sure. I was afraid to completely power the phone up with all the water in it, so first we had to dry it. And then at that point, I made a decision. I had talked, and eventually I was told that the phone was a brick, that we probably wouldn't be able to do anything with it, so I went ahead and tried to rebuild it. I was able to rebuild the phone and then extract data from the cell phone.
Let me hand you these documents and ask you to recognize these pictures.
Yes.
What are those pictures of?
They're photos of the cellular device as I was trying to see what I needed to do to fix it.
I don't know if we could mark this as the next exhibit.
Is that collective?
Yes, there are, I believe, 5 pictures.
5.
Yes. And then, Investigator Kate, if you don't mind, I'm going to have you step down and stand right here and go through these pictures with the jury and kind of explain what you did with this.
I'm sorry. 52. Right.
Okay, let me hand you Exhibit 52, and you can just stand right here and never look at the 2 jurors over to the side. Go.
So this is after I had the front assembly. Removed the phone where it popped up, and you can see standing water. Sorry. The cell phone. So generally there's tabs inside, especially Apple devices, that will show if there's moisture. I didn't have to even rely on those because there was standing water in it. This is a better look of the water that's in the phone. If you can't see it, let me know, and I'll put it on there. This is the back side of the front assembly, and there's a shield there. It's a piece of metal, and you can see water droplets on it. That's as I'm holding it up, so it's stuck to the shield of the front assembly. Again, this is, I removed the battery. The main reason I removed the battery, I didn't want it to somehow, someone plug it up or there was no power to it. So I removed the battery, and again, underneath the battery, you can see there's water underneath it as well. A lot of these photographs are, you can't see the photo of the phone. The other phone, you can't see the photo. If this is a good front assembly. After it's been removed, it has the same water.
Now, Investigator Payne, when you first received that phone, you said there was a bow in the phone. Can you show me what your hand with that phone was like?
This was you got the phone in front of this boat, and inside the Apple products, it has it's a frame. It's small. The 95 is Apple product. That frame, the way it is, the way it's set up, is supposed to protect it, the components inside of it, but also protect it from the boat. If you leave it in your back pocket and set down, it's supposed to kind of help with that. But if it didn't have it,
They would just break on it.
you break all that. You have broken screens. A lot of times it's a function, but you might lose some of the, being able to maneuver through the phone or the apps on the phone. The frame,
You can go ahead.
the frame on the device was bowed to the point where the screen was fractured, right? And when you removed everything, you could still see, you couldn't even get the screen to pop back on completely. The new screen that I put on it, this was after I've already straightened it out to some degree, it doesn't make a complete seal because the screen is still bowed.
So you indicated that you also had to dry out the particular phone and the components of the phone. How long did that take?
Hours. I left it, I may have left it overnight. I'm not sure, it was hours. I was afraid to, when I replaced everything, I was kind of afraid, like there may be some moisture still in it, but thankfully there was not, or at least it didn't affect the phone coming on.
Okay. So at some point in time, after that phone had dried and you went back and you looked at the phone, were you able to do an extraction of this phone?
Yes.
And explain to the jury what an extraction of a phone, what does that mean?
So when we hooked the phone up to a computer, and that computer has software that can gather the data from the phone, put it into a format that's easy to read, and you can go through it and you can manipulate as far as the timeline, like, okay, I want to see on this date and time what occurred. So using that technology, I hooked it up and thankfully was able to extract some data. A lot of times we lose data from the device that we perform these on.
And so in this particular case, are you 100% certain that you got all the data off that phone that was available before it was bent and put under the water?
It's missing some data, or as far as the extraction is missing some data. I can't explain that. It doesn't pull everything, but I was able to get a lot.
It doesn't tell you what you don't have.
It doesn't tell you what you don't have. No.
Was it apparent to you, though, that things that are in your extractions where you don't have a phone that's been manipulated were not there?
Yes.
Okay. Now, I'm going to ask you about two different things that you found with this particular device. Do you recall finding any messages to someone named or someone listed as Callie?
Yes.
Let me show you this and ask, do you recognize this document that I'm handing you?
Yes.
What is that?
It is a photograph of, again, we don't get everything from the phone. And I was afraid that any manipulation of this device, it could short out and we wouldn't have anything. So when we had it powered up, I took some photographs of some text messages that I thought were, that had evidentiary value to them.
Okay, and so the first, if we could make this the next slide.
Could I see that? When you make that?
All right, that'll be marked and filed as number 53.
So you have for the record, we do have an exhibit 18 on one side and this is exhibit 53 on the other.
Well, let's call the side that's got the.
And they're marked.
Does that have any consequence what's on the back?
This is exhibit 18 from earlier this week. I'm just reading on the board.
Did you run that
From
poster
last
board?
week or-
Okay.
That was from last week. It's not last week, from this earlier in this case, from earlier this week. This is an exhibit in this case.
All right, well, we'll multitask and call one side 18 and the other side 53.
Thank you. Okay, so this is a screenshot of the first one is that it says Callie and it has a phone number. Is that correct?
Yes.
And then if you could tell the jury, if you could just read the text messages in blue, would those be, the ones in blue, are those from the owner of this phone in exhibit 48?
Yes.
So the owner of the phone, just read them to the jury.
It says, I need you to get that gun, Callie, FR ASAP. It's on the side by the air conditioner. In the bush, My phone is about to die. They are taking me to UT.
Okay. So the first text message that you read says, I need you to get that gun, Callie, FR ASAP. Do you know what FR is? That something that you've seen typically whenever you've looked at extractions?
Yes.
Do you know what FR means?
Yeah, it's like, seriously, for real, I need you to get this.
Okay, so I need you to get that gun, Callie, for real ASAP. And then the next one says it's on the side by the air conditioner. Is that
Yes.
correct?
Yes.
In the bush.
In the bush.
My phone is about to die. They're taking me to UT. Is that correct?
Yes.
Okay. And is there a timestamp associated with that particular message sent from the owner of this phone to Callie? Is there a time?
Yes. So above it, it says yesterday, 9:23 p.m.
So it's
That's-
associated with 9:23 p.m. Is that correct?
Yes.
Let me show you. Show you this and ask you to recognize that.
Yes.
And what is this that I can do?
It's photographs taken of.
Would it be at all possible for the state to show me what they're taking the minutes before they?
I think this may already be in evidence.
It's already in this.
What exhibit number is it?
It's going to be exhibit number
This is 7.
7.
Joe Key text.
Yes.
Okay. Do you recognize this?
Yes.
Is this, and let's put this down
Sorry.
so see it, sorry. Is this, actually, let's do this. I'll put it right here. And you can come stand beside me that way so you can see too. Tell the jury what this is.
This is a series of photographs taken of the device.
And this is to the phone number that's listed as Joe. Is that
Yes.
correct? So these are text messages from the owner of the device to Joe.
Yes.
All right.
Send back and forth.
Okay. And so, Your Honor, I don't think we need to belabor it because we've already been used to the jury. But the one that's significant, can I ask you about this one that says, go to my house the back way and get my gun out of the bush under the air conditioner. Gavin shot Destiny, then come to UT and I got you for free. The police are there, but if you park in the alley and walk up, you're good because they're in the house. What is the time of that particular message?
So 9:26 p.m.
Eric, can we mark this also as Exhibit 7 just so that it's clear?
That's fine.
You also call it that also exhibits.
It's all exhibit 7. It's the text messages. Trading involved.
Did you also look at the phone and look at incoming and outgoing calls after 8:42 p.m.?
Yes,
Did you prepare a document with those items?
I did.
Can you this and ask you to recognize this document?
Yes.
What is that document?
It's a timeline of phone calls and text messages incoming and outgoing.
Okay. And so if you could explain to the jury, you started looking at the phone calls incoming and outgoing at 8:52 p.m. on September 14th, 2019. Is that correct?
Yes.
Okay. You'll just read down for the jury and then we can make that the next exhibit.
So, starting here. 8:52:42 p.m. There's an unanswered incoming call from Joe. 8:53 p.m. Outgoing call to 911 has a duration of 3 minutes and 20 seconds.
So that 911 call you said was at 8:53:00 p.m.
Yes.
And you said it lasted for 3 minutes and 20 seconds?
Yes.
Go ahead.
At 8:56:42 p.m., there's an outgoing call to Callie at 865-830-2232. It was 35 seconds in duration.
Now, when you say Callie, is that the name that the person that has the phone has listed? That's what they have labeled the number as?
Yes.
Go ahead.
8:59:04 p.m. Unanswered incoming call from Callie. 865-830-2232. At 9 p.m. and 37 seconds, unanswered incoming call from Callie. 865-830-2232. 9:03:43 p.m. Outgoing call to Tab. 865-740-1383. That was
I'm sorry, who?
Tab, T-A-B. That's the context label in the device. That was 31 seconds in duration.
So that call connected.
To something. I don't know if there was a conversation, but 9:04:38 p.m. outgoing call to Tab once again. The same number, 31 seconds in duration. 9:05:14 p.m. outgoing call to Tab, same number, 30 seconds in duration. 9:05:59 p.m. outgoing call to Melissa, 865-679-1596, 42 seconds in duration. 9:06:27 p.m. incoming text from Tab, 865-740-1383. The text read, "I'm driving mom to Walmart, honey. She won't let me answer the phone." 9:06:35 p.m. outgoing call to AJ, 423-612-3972, 6 seconds in duration. 9:13:03 p.m. outgoing call to Callie, 865-830-2232, 1 minute and 21 seconds in duration. 9:19:07 p.m. outgoing call to Callie, the same number, 56 seconds in duration. 9:21:43 p.m. outgoing text to Tab at 865-740-1383. "I just talked to your mom. Destiny got shot." 9:22:10 p.m. outgoing text to Tab at 865-740-1383. "I need you to do me a favor ASAP." 9:23:08 p.m. outgoing text to Callie, 865-830-2232. "I need you to get that gun, Callie, FR ASAP."
Was that the text message that we were looking at earlier?
Yes.
Okay.
9:23:21 p.m. outgoing text to Callie, same number. It's on the side by the air conditioner. 9:23:26 p.m. outgoing text to Callie, same number, in bush. 9:24:16 p.m. outgoing text to Callie, same number. "My phone is about to die. They are taking me to UT." 9:26:54 p.m. outgoing call to Joe, 865-208-2836, 35 seconds in duration. 9:28:02 p.m. outgoing call to Callie at 865-830-2232, 1 minute and 34 seconds in duration. 9:31:29 p.m. outgoing call to Joe 2, 865-888-1690, 51 seconds in duration.
Okay, and the way that you got this particular list, how did you get this particular list of incoming and outgoing calls and text messages?
Within the extraction I performed on this device, there's a way that you can have that put in a timeline. So I went through that and marked everything as it happened prior to the 911 call to the last incoming or outgoing text or phone call to or from the device.
Now, I noticed that Callie's text message is in this chain. Is that correct? The ones
Yes.
that we were just talking about, but Joe's are not. Do you have a reason for the jury why that is? Do you know why that would be?
Again, some things when we extract from the device, for some reason, it will not get certain things.
And so is that why you also took physical pictures of the conversation with Joe as well?
Yes.
We could make this the next exhibit.
Marking files 54. 54.
Pass with us.
Property damage.
Afternoon.
How you doing, sir?
Good, you?
Doing good.
Investigator?
Investigator, it's fine.
Okay. I just want to give you your title. I'll make sure. We've known each other a long time now.
Yes, sir.
Okay. When did you get trained to fix phones?
The last training I went to, it was cut short because of COVID. And then trial and error, a lot of it.
Because I'm going to be calling you next time one of mine breaks. The frame was fragile, you say. The frame of these phones are fragile.
Depending on which way you're
Yeah.
manipulating them.
Long ways, more fragile than crossways, right?
No, more fragile long ways.
From end to end.
Yes.
Yeah. It's not, you can't try to fold it sideways. You're not going to.
Well, depending on what part of the frame you're talking about, if you can imagine a small rectangle box without a top or bottom. So if I try to fold it halfway, the side supports or the top and end supports would create resistance to that. If I'm trying to fold it in lengthwise, the side supports create resistance to that.
I think you were saying you could bend it if you put the phone saddle.
Without the frame, it would very easily do that.
When did this phone get bent?
I can't say.
Yeah, that screen looks pretty bad. Usually, when you're out there talking to folks on the street like you do who are drug users, right? You see some pretty bad phones.
I've seen some Pretty bad phones.
Well, you were shocked. Function.
Sometimes, possibly.
You don't know when this one got bent.
I do not.
Now, you didn't have, your job at this point, outside of this courtroom, is as a drug investigator, right?
Yes, sir.
You didn't have any drug investigation going on in which Ms. Howington's name came.
There was no known drug investigations that I'm aware of.
Like they were happening, you'd be aware of it.
I'm not sure.
Were there any illegal drugs found in this case that you're aware of?
I'm not aware of that.
Now, when I ask you, you said that describe how short normal drug transactions are. That's kind of small time drug transactions, right? Big drug transactions might take a little more time.
I'm not sure. They're usually pretty quick.
Well, is it possible for you to make mistakes?
Me?
Yeah.
Yes, sir.
I want to ask you about the Bean case. Do you remember the Bean case?
During transactions, there are a lot of times firearms present.
You would also agree that in small time drug transactions, a couple of pills here, a couple of pills there, that is not normal that guns being present.
Well, when you say normal, to me, it depends on the type of narcotics. It depends on the person that has the weapons. A lot of times, the amount of drugs really, it could not be a reason that they have it as far as the firearm being present. If I have that and I'm not afraid of anyone coming in and robbing me or whatever, then I may or may not have a firearm.
And how often are drug deals taking place out of a drug dealer's house? Or where they live and where they stay?
I've been involved in it occurring multiple times.
You know what trap houses are, right?
Yes.
What's a trap house?
A trap house could be a location that's specifically for selling narcotics or holding narcotics to be sold at a different location.
At a different location of where the place the dealers use it, live,
Yes.
right? Do you remember testifying in a hearing on Friday on this case?
Not somewhat.
And I ask you, it's really on small-time drug dealing that guns are not as prevalent as they are in large drug dealing.
That wasn't specifically, if I remember correctly, you asked me to the effect of, is it possible that a small-time drug dealer wouldn't have a firearm? And I said, yes, it's possible.
No further questions, John.
Any further? You may step down, Investigator Pate. Thanks for being here. Call your next witness.
Step back in.
Yeah, since you got gloves, I'll go ahead and put that back in there. Admitted, or are those already? Okay. So same thing, I guess.
Your Honor, at this point, we do have a copy of Ms. Oliver's medical records from the medical center about the affidavit with it, anything like that.
All right, mark and file. That's from UT Medical Center. Medical records for Destiny Oliver.
The next witness that we are going to call is Dr. Amy Hall.
Ask Dr. Halls to step in, please. Raise your right hand, please. You solemnly swear or affirm the testimony about to give to be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Have a seat. Adjust the microphone if you need to. We're up to 56, correct, Lisa? The medical records were 55, correct?
That's correct.
So the next exhibit will be 56.
That's correct.
All right, thank you.
Can you please state your name and spell it for our court reporter?
Sure. My name is Dr. Amy Hawes, Hawes.
And where are you employed?
I'm currently employed at the Knox County Regional Forensic Center here in Knoxville.
And what is your specific job title there?
My job title is Assistant Medical Examiner and Forensic Pathologist.
Can you tell the jury a little bit about, how long have you worked at the medical examiner's office?
So that's a little bit more complicated than what it first might seem. I was first employed at the Knox County Regional Forensic Center in 2015.
I stayed there for a number of years and then left to go work for the state medical examiner's office. But while I was with the state medical examiner's office, I continued to do autopsies on a part-time basis at the Knox County Regional Forensic Center. Now I'm back full-time. So I guess the short answer is off and on I've been employed there in some capacity since about 2015.
But we would stipulate that Dr. Hawes is.
Same thing, ladies and gentlemen. The parties agree that Dr. Hawes is an expert in the field of forensic pathology. For that reason, the rules of evidence provide she may offer opinion testimony.
All right. I'm still, if you wouldn't care to just let us know a little bit about your education and what degrees, certificates that you hold, even though we have stipulated that you are an expert in this case.
Sure, I'll do it briefly. I got a bachelor's degree in chemistry at Middle Tennessee State University. I then went to medical school at Meharry Medical College in Nashville, where I received my medical degree. Then I did 5 years of training in anatomic and clinical pathology at Vanderbilt University Medical Center. Then I did an additional year of training in forensic pathology at the Dade County Medical Examiner's Office in Miami, Florida, and that was called the fellowship year. And then after that, I started a full-time job.
So back in September of 2019, were you asked to do an autopsy on a 5-year-old by the name of Destiny Oliver?
Yes.
And did you actually conduct that autopsy and put your results into a report?
Yes.
And I'll show you this. And do you recognize that document?
Yes, this is a copy of the autopsy report.
Okay, and is it a fair and accurate copy of the report that you generated in this case?
Yes.
We can have that.
Let the autopsy protocol be marked in files Exhibit 56.
Okay, Dr. Hawes, before we go into your specific report here, if you wouldn't mind just giving the jury a little bit of background of when you receive a body and you're asked to do an autopsy, just kind of walk us through the steps of what it is that you're looking for and doing throughout that process.
An autopsy is what I like to describe as an extensive surgical procedure. In a medical examiner autopsy, the purpose of that is to determine the cause of death and the manner of death. In other words, how and why someone has died. In short, it involves documenting the outside of the body as the body is received at the office. Then we do an external examination where we look for any injury or trauma or evidence of natural disease on the outside of the body. Then we turn to the internal examination where all of the internal organs are examined. And again, we document any trauma or natural disease that may be there. We also collect evidence, and we'll also collect certain specimens for toxicology where we look for drugs or alcohol in the blood or other body fluids.
And so in this case in particular, do you recall when it was that the body of Destiny Oliver arrived for you to examine?
Well, I did my examination on 9/15/2019. She may have gotten there the day before. I don't have that information in front of me.
Okay. And so looks like you've got, I want to go a little bit through your report here. So it looks like you've got that the Destiny was 48 inches, 48 1/4 inch, is that right?
48 1/4 inch long, yes.
So she was about 4 foot tall.
Roughly.
Okay. And she weighed 56 pounds. Is that accurate?
Yes.
Okay, so I want to now go through and talk about these specific injuries that you noted on Destiny's body. Dr. Ross, did you meet with our office earlier and review this demonstrative aid here?
Yes.
Okay. And so did you actually place the object through it like this in our office earlier?
Yes.
Okay. And so, again, we also measured this, and it was about 2 foot tall, and we said that Destiny was about 4 foot tall. Is that accurate?
Correct.
Okay, so we know that it's not necessarily the size, but we really just want to look at the wounds themselves. And so when you are looking at a body and looking at wounds, do you also take photographs of those wounds?
Either I take the photographs or typically they're done at my direction by an assistant.
Okay, and so I'm going to show you a number of photographs. Seven photographs in total. Can you tell me if you recognize those?
I do.
And are those the photographs that were taken of the injuries noted on the body of 5-year-old Destiny?
Yes.
And Your Honor, if we can have this file, this collective.
57.
Okay, so I'm going to kind of go through these photos with you. There's not a great place to put this, but if you wouldn't mind, so just on this first photo here, can you just point on here where this injury was sustained?
So the first injury that you're pointing to in this photograph is what I call the back of the hand. The reason why it's called the back of the hand is because when medical examiners describe injuries, we do it in what's called the anatomic position. And that's when the deceased person has their hands down by their side and the palms forward. So what I call the back of the hand, somebody may call that the front of the hand, but technically it's the back of the hand. So that's what this hole here, or this, when the rod goes in this portion of the hand, that's what it is describing.
And were you able to determine whether this was an entrance wound or an exit wound?
This is an entrance wound.
Okay, and were there, what sort of indications do you look for as far as that goes? Are there any indications on this particular wound that made you think that it was an entrance, not the exit?
Yes. So first and foremost, it's a very symmetrical, very round wound with a punched out hole in the middle, which is characteristic of an entrance wound. It also has a nice symmetrical abrasion around the edge of the wound. And also, probably more importantly, on this wound, there is something called gunpowder stippling around the wound, which is an effect that occurs on the skin from unburnt gunpowder. So that gunpowder stippling helps us determine within a range how close or how far away the gun was held when it was fired.
Were you able to make that determination in this particular case?
So in this particular case, with this stippling, I would say the gun was held anywhere from a few inches up to a couple of feet away. And it depends on the type of gun and the type of ammunition that was used. Now, the gunpowder stippling here was fairly sparse. There wasn't a lot of it. So that tells me it's probably on the end closer out to 2 feet or so. But that's an estimated range of where the gun was held.
Okay. I'm going to just kind of walk around to make sure the jury can see this. Move on to the next photograph here. Is this just a closer up photograph of the same entrance to the back of the hand, same entry window to the back of the hand?
Yes.
Okay. So this third photograph here, can you describe what that depicts?
This is a photograph showing the right hand, Destiny's right hand, the palm side, or what I would call the front, and you can see the exit wound there at the base of the thumb there on her right hand.
Okay, and so on our demonstrative here, that's going to be, like you said, right here, kind of before it then extends into her chest.
Assuming that that's the same bullet that exited her hand and entered her chest.
This was the exit wound from the entry wound that went on the back of her hand.
Yes.
Fourth photograph in this series, that's just a closer up photograph of that same wound that we just talked about on the front of the hand?
Yes.
Okay. We'll go on to next photograph here. Can you tell us what this is?
That is the entrance wound on Destiny Oliver's chest.
Is there anything significant about this entrance wound versus the entrance wound on the back of her hand that's different or anything?
So two things of significance. The entrance wound on her chest has no soot, no burnt gunpowder, or no stippling, which is unburnt gunpowder, on the chest. There's also a very irregular shaped abrasion that's very different than the one we saw on her hand. In my experience, that very irregular shaped abrasion is consistent with what's called a shored, S-H-O-R-E-D, abrasion or shored entrance wound, which tells me that probably something was against the skin when it was fired. And so it causes friction between the two surfaces and it abrades or rubs off part of the skin. So in this particular case, if properly aligned, when the bullet entered her hand and exited the palm, if her hand was here on her chest, that could be a reason why that entrance wound appears shored on her chest.
I know we talked about if our hand was positioned here, could that also, the shoring that you talked about, could that also be caused if the victim was holding something in her hand, like a remote or something to that effect?
Yeah, it could be anything that's next to the skin.
All right, and then we're at the last two photographs here. If you could, let me let you in that one. And which of the wounds is that?
Oh, that's the exit wound on her back.
Okay, so that's this one here that was demonstrated where it's coming out finally.
Yes, these are obviously approximate locations.
Okay. And so, do we believe that, obviously, the entrance wound on the front of the chest, we believe that the bullet that entered there then exited from the back there?
Yes.
Okay. I think that this final one, is that just a closer up image of that exit wound from the back?
Yes.
Okay. All right. Were those the only, so we've got an entrance wound on the hand, exit wound on the other side of the hand, an entrance wound to the chest, and exit wound on the back. Were those the only injuries that you noted?
Yes, that's correct. There were 2 gunshot wounds, one to the hand and one to the chest or torso.
Okay. And if we think that there was just one bullet fired, that's why we're talking about it could potentially be that it came through the hand and then into the chest. Could that explain why there's 2 there's 2 wounds, but if only one bullet was shot? Would that explain that?
Yes, if the physical evidence at the scene indicates there was only one bullet, then the only explanation for how these wounds occurred is approximated here on this doll.
Now I see that when we're looking at your final report here, on the second page, you've got B, and A, B, C, D, E, and then so I'm looking specifically at C. And so you've listed the overall wound path front to back and downward. Can you just explain to the jury what you mean by that?
Sure, and to be clear, I'm referring to the path of the gunshot wound that goes through the torso, which is the chest part here. And so again, when medical examiners describe the wound path of a bullet, we can only describe the path it takes in the body. It's not meaning that anybody was standing in any one particular position or how the gun was held, anything like that. It only refers to how the bullet went through the body. So in the second gunshot wound here, the overall wound path was front to back, meaning it went from the front of the body to the back of the body and downward, which simply means that it exits slightly lower than the entrance wound. And in this particular case, the entrance wound was about 11 inches below the top of the head, and the exit wound was about 14 inches below the top of the head. So there's only about a 3-inch difference between the level of the entry and the exit.
When the bullet entered through the front of the chest, were you able to determine whether or not it hit any sort of vital organs or anything like that?
It did. That gunshot wound of the chest or torso injured rib, heart, esophagus, aorta, which is the major blood vessel that extends from the heart to the rest of the body, the spine, and the spinal cord.
Do you believe that the gunshot wound that she received in her chest, do you believe that to be fatal?
Yes.
I also briefly want to talk to you, Dr. Hawes, about, I know we talked about this a little bit, but as far as the timing of when this wound may have caused Destiny's death, can you speak to whether or not it was instant, whether or not it may have taken some time or anything like that?
So her death would not have been instantaneous. The only thing that will explain or cause an instantaneous death is a severe injury to the brain or upper cervical spinal cord, meaning up here in the neck. Obviously, that was not the case here. So what the medical literature tells us, and in my training and experience, that you have about 15 to 30 seconds of reserve of oxygen in your body. So because of the organs that were hit, she could have potentially remained conscious for anywhere between 15 to 30 seconds. That's an estimate. It certainly could have been shorter, and it could have been a little bit longer.
I'll pass the witness, Your Honor. Thank you, Dr. Hawes.
Good afternoon, Dr. Hawes.
Good afternoon, sir.
Doing okay up there?
I think so.
I don't have much to ask you. I do want to note that in your report, you report on the first page that the body was normally developed and well nourished. Is that
Yes.
true? Okay. And you talked about the anatomical position. So that's what MEs use everywhere, so that everybody knows what posture they're talking about. Right? It's the same as.
Yes, sir. It's so we can have a standard frame of reference when we're referring to different locations on the body.
If we tell you that what we believe the evidence shows that there was a TV remote that has a bullet defect in it between her hand and her chest, that wouldn't surprise you.
No, sir, it wouldn't.
Okay. And do you have the measurement from? I guess you would measure from the midline.
Yes, sir.
To that hand injury, or can you do that? It has to be from the chest.
So the measurements that we give as standard is below the top of the head, so down this way, and then to the right or left of midline. So if you have an imaginary midline right down the middle, we'll measure either to the right or left of that midline, either on the front or back of the body.
And on that chest wound, the entry wound, can you tell us what the measurement from the midline?
Yes. On the chest, the entrance wound was 3 1/4 inches left of anterior midline.
So you don't know how wide her body was across the chest, do you? Have that measurement?
No, sir.
And this rod is an approximation.
It is absolutely approximation because number one, this doll is obviously a very different size and shape, and number two, it's just impossible to put the rod in to be exactly the same. So it's just for demonstration, for an approximation of where the bullet path was.
And that bullet path just tells us where the bullet struck her body on entry and where that bullet struck her body on exit, and the movement through the body, right?
Yes, sir. And to be clear, the bullet hit rib, which is bony, and if it hit the remote control, which is again another hard plastic thing, the wound path could have been deflected, which would change the normal trajectory if it had not hit something that was hard. So in other words, the bullet could have been deflected and changed that where the exit wound is.
And even though this is just an approximation, the other problem is if I were to tell you that the evidence appeared to show she was lying on a couch on her side, then this looks a little different, and it looks different again depending on how far she's leaning back or how far she's leaning forward, right?
There's nothing about this trajectory that would preclude her from being laying on the sofa. No, I mean this trajectory could absolutely be from her lying on the sofa.
Thank you, Don.
Yes, sir.
Any further questions? You may step down, doctor. Be
Thank you,
careful
sir.
of the mannequin. Call your next witness. Ladies and gentlemen, the state of Tennessee has rested its case in chief. There are some matters I need to take up with the lawyers in your absence. We will get you back in here shortly. All rise for the jury. Mr. Wayland, do you have a motion pursuant to Rule 29? Have a seat, Ms. Howington.
I did.
But pursuant to Rule 29, we would ask at this time for a judgment of acquittal. As to the first count of felony murder in the perpetration of aggravated child neglect, there's been really, there's controverted testimony about where the gun is. In this case, they asked her where the gun was kept, and she told them in the closet. We know that there's been testimony that on the 12th, she brought that gun out of the house when Mr. Oliver was there and refused to leave and was raising hell and fighting with Callie. And she pulled the gun out, and either pointed it or didn't point it, and told him to leave again, and instead he took the gun away from her, broke it down, and tossed it, and believed that Callie went to pick it up. That's what Riddle verified that testimony by that statement by her, by talking to those two witnesses. And we talked about that while he was on the stand. So Callie hasn't been called, Mr. Oliver hasn't been called. We don't know where the gun was on September 14th. But the story, as she said in text messages to Joey from a few minutes after the shooting, to go get that gun, Gavin shot Destiny. I think I heard the state say in voir dire, and maybe even an opening statement, that they weren't saying that Miss Howington shot her daughter. But they were upset because of these changing stories. Well, the changing stories were some on Miss Howington, and she explained that she told them about the unidentified black male coming in and shooting because she was trying to protect Gavin. She told him, asked Joey to go get the gun. She's doing that to try and protect Gavin because if she knows the gun's going to get tested, it's going to say that gun shot Destiny, so there's only two of them it could be. It's her and Gavin, because they're the only two people in the house. They start throwing other stories and possibilities in, and she refuses about Antoine for a while, and then finally breaks down and says, "Oh, you're right. Okay, you're right. I can't take it anymore." And then they stop screaming at her, and they start being nice to her once she adopts what they want her to adopt. I don't think there's any evidence that she intended for that gun to be accessible to Gavin. And that's the question. Was there any evidence that she intended for that gun to be in a place where he could get it? I don't believe there's been any evidence to that point.
Well, I think it would be that she knowingly placed the gun in an area or place. She's obviously charged with a legal duty. She's the child's mother. Let me hear from the state as to counts 1, 2, and 3.
Sure, Your Honor. So, as the court is well aware, the defendant in this case gave a litany of different stories about what happened and where the gun was and how it got there. I want to focus specifically on her statements where she goes through where did the gun come from that particular day. And so her first story, when she talks about where the gun come from, she says Anton got the gun out of the closet. That's her first story that she tells. As the interview goes on September 14th of 2019, the next story that she gives is that Gavin, not Antoine, but Gavin was the person that got the gun out of the closet, etc. And she gives a story about how there was a stool that got brought over and how he put on high heel shoes and how he climbed to the top of the closet and he got the gun out of the closet. That's the next story that she gives, Your Honor, and the one that I think is the most significant is the last story when she talks about how the gun came out that day. And her statement the very last time is that she got the gun out of the closet. And that's significant because here she's told all these other stories. And on September 15th of 2019, the second day that she's interviewed, she makes admission that she, in fact, is the person that went and got the gun. I think that that's significant because she puts it first in other people's hands, first in the hand of Anton, then in the hand of her child, getting it out of the closet in a story that's not plausible given the other proof in this case. And then finally, the last story that she gives to the officers, after they show her that she is not being truthful about what she's saying, her final story is that it's her that went and got the gun. So I think that that's the most realistic story. I think we've put on circumstantial evidence that she's the person that got the gun out that day. There's also evidence that the court heard that there was an incident that happened on September 12th. Her recitation of what happened on September 12th, a few days earlier, started with other people getting the gun as well. And then her final story on September 12th is, in fact, it was her that got the gun. So that's another pattern, and that's consistent with everything else that we have going on in this case, which is someone else did it, someone else did it, someone else did it, and then finally she makes admissions that it was, in fact, her. So I think that there's been enough proof that's put on for this to go to a jury and for them to determine whether or not her handling and whether or not her behavior that night was negligent.
All right. Well, what the court has, Ms. Howington, the court at this juncture is required to consider, pursuant to Rule 29 of the Tennessee Rules of Criminal Procedure, the evidence in the light most favorable to the state of Tennessee, which means I don't take credibility into consideration at this juncture. All the court is concerned about is there evidence within this record which, if believed, would meet the statutory criteria and elements for each of the crimes charged. The easy ones are obviously the false report and the tampering with evidence and attempted tampering with evidence. But as to the principal counts, the first three counts, aggravated child neglect, where serious bodily injury occurs, aggravated child neglect, the use of a deadly weapon, and then the count which stems from those two counts, the felony murder count, because of the death of Destiny, the court finds that there's sufficient evidence for the case to go to the jury. The text message in and of itself that sent that night on the way to UT that Gavin shot Destiny means that this court, that's an admission in conjunction with the other evidence in the record that the firearm, which was not insignificantly hidden immediately afterwards by this defendant, I mean literally within a minute or two of when Destiny had been shot, the firearm was hidden. That same firearm, by this defendant's admission, was the one that was used and that killed her daughter. And that firearm, by her own admission, was a weapon that she had there, that she had acquired. She is the mother of this child, owes a legal duty to the child, and the admission in and of itself, if I ignored everything else, the admission that Gavin shot Destiny means that that small child has to have had access to that firearm in some shape, form, or fashion, and it would have been impossible based on the evidence that has been introduced to this at this juncture for that child to have climbed up into the closet and gotten it. So when the court considers all the evidence in this record, there's enough there for the case to go to the jury. What the jury does with this case, I don't have any idea. That's their prerogative. The court's only function and task at this juncture is to determine whether or not the state's made what's called a prima facie case, and the court finds that they have each as to each of the 6 counts. Now, you're going to be required, General, to elect. I think the only case that we have the necessity for an election on is, the only count rather, is the false report, which, because quite frankly there are, by Ms. Howington's own admission, there are a multitude of false statements that are given to KPD, but in order to ensure unanimity, the court is going to require the state to elect which false statement it is relying upon in asking the court to, or the jury to find her guilty of initiating a false report.
The state's going to elect that the statement that she gave that an unknown black male shot Destiny. The statement,
Why don't we limit it further to say the statement to Investigator Riddle at the scene at 502 Balsam about the black male, correct? The unknown black male. Is that the state's election?
I don't know if she describes him as a black male. I'm looking at I can play the statement if the court wants me to. The 911 call is not what we want to elect because the 911 operator is arguably not a law enforcement officer. I can just give you quotes. He just came in here and we were all sitting right here. I don't know who he is. I don't have a clue. I've never seen him in my life. She was laying on the couch. I was sitting right beside her. He was sitting right here. Her statement to Tim Riddle at the scene.
Okay, so the unknown, can we say the unknown male
Yes.
in the statement given to Detective Riddle at the scene? All right, rather than doing a separate election instruction, I think the cleaner way to do this is just simply to insert within the language of count 4 in the elements that'll be where the crime will be defined as just so the defendant initiated a report or statement to a law enforcement officer concerning an offense or incident within that officer's concern to wit, and then I'll fashion language on that, narrowing it to that one statement. Everybody agree?
Yes, sir.
Yes, sir. So we did talk yesterday, I think, about counts 5 and 6 and whether or not election was necessary to determine.
Well, I think we're going to have to define, I don't know that it's really an election, it's more of the same thing. I'm just going to further define. So count 5, I've already put in the instructions, concealed a firearm with intent to impair its availability as evidence in the investigation. And then count 6 would be an attempt, the defendant altered a thing to wit a cellular phone with the intent to impair its availability as evidence in the investigation. Everybody agree? Okay. Are you prepared to do the moment colloquy?
Yes, sir.
Would you like to do it or do you want the court to do it?
Don't mind doing it.
All right. Ms. Howington, Mr. Whalen needs to ask you some questions on the record concerning your decision about whether or not you will testify in this case. Please listen carefully, and then the court may have a couple of follow-up questions. Go ahead.
Ms. Howington, if I explain to you that you have the right to testify at this trial if you wish, and that you have the right to remain silent if you wish.
Yes, sir.
And have I advised you as to what I think about whether or not you should testify or whether or not you should remain silent? Have I explained to you that while you should listen to my advice, that the decision is ultimately yours and yours alone to make?
Yes, sir.
And have I explained to you that if you choose to testify, like any other witness, you would be subject to cross-examination on the scene?
Yes, sir.
And having listened to that advice and been advised of those rights, have you made a decision about whether or not you wish to testify at trial?
Yes, sir.
And what is that decision?
Yes.
Yes.
I will testify.
All right. The decision that you announced, Ms. Howington, that you're going to testify, is that your decision?
Yes, sir.
Okay. All right. Let's take about, both sides satisfied with the moment colloquy?
Yes, Your Honor.
All right, let's take about 10 minutes, and we're going to come back in here. Mr. Whalen, I will recognize you at that time. I'll instruct the jury that the state has rested its case in Chief Ms. Howington's under no obligation to present evidence, and I'll recognize you to present evidence if you so choose. You can call your first witness. All right, let's take 10 minutes, and we'll get started.